Ask everyone please be seated. Case of People versus Jussie Smollett. I ask the lawyers to identify yourselves and spell your names for the court reporter, please, starting with the Office of Special Prosecutor.
Your Honor, Dan Webb from the Office of Special Prosecutor. Go ahead, everyone.
Sean Weaver, S-E-A-N-W-I-E-B-E-R, Deputy Special Prosecutor from the Office of Special Prosecutor.
Samuel Mendenhall, S-A-M-U-E-L-M-E-N-D-E-N-H-A-L-L, from the Office of the Special Prosecutor.
Counsels.
Thank you. Judge, good morning. Damien Uche, M-E-N-Y-E, last name U-C-H-E, from Mr. Smollett.
Good afternoon. Shay Allen, first name is S-H-A-Y, on behalf of Mr. Smollett.
Heather Riddell, W-I-D-E-L-L, on behalf of Mr. Smollett. Tamara Walker, T-A-M-A-R-A, on behalf of Mr. Smollett.
Good afternoon, Mark Lewis, L-E-W-I-S, on behalf of Mr. Smollett.
Good afternoon, Tina Glandian, G-L-A-N-D-I-A-N, on behalf of Mr. Smollett.
Thank you, counsels. Everyone may be seated. All right, let the record show that a jury trial was held in this matter. Counsels, just find a seat if you will, please. Trial commenced on November 29th of 2021, concluded on December 9th of 2021. Mr. Smollett was found guilty by a jury of 5 of 6 counts of felony disorderly conduct, a Class 4 offense. I expanded the filing period for filing the post-trial motions beyond the 30-day limit due to the holidays and other restraints involving this case. I have received an 83-page post-trial motion filed by the defense and a 13-page response to the post-trial motion filed by the Office of Special Prosecutor. I will allow this, the defense to present arguments in support of your written motion. Ms. Glandian, do you wish to address the court?
Good afternoon.
Counsel.
As the court knows, we filed a comprehensive motion for judgment notwithstanding the verdict and or for a new trial outlining 13 different errors that occurred during Mr. Smollett's trial. However, the legal errors impacting Mr. Smollett predate this criminal trial and began long before this case was even assigned to Your Honor. I know the court has read our papers and there's been voluminous briefing, and we did incorporate by reference all of our prior briefing and arguments in this case. So I'm not going to belabor every single point. However, I do want to talk about 2 categories of critical errors that have permeated this trial. And that began again at the very outset and impacted this initial complete prosecution against Mr. Smollett. And in doing so, I'm going to highlight some of the most flagrant violations. The first category of legal error relates to this entire second prosecution of Mr. Smollett. The court knows the history, everybody knows the history, but I'm going to outline a couple key facts that occurred. A 16-count indictment was originally filed against Mr. Smollett on March 7, 2019. As part of a negotiated resolution, on March 26, 2019, the state's attorney's office moved to nollie pros all 16 counts. The Honorable Stephen Watkins granted the motion and dismissed the case against Mr. Smollett. As part of this negotiated agreement, Mr. Smollett was required to satisfy the Cook County State's Attorney's Office as to his long-standing community service, and he forfeited the $10,000 bail bond, which he was not required to do. Weeks after the case was dismissed on April 5th, 2019, a pro se litigant who lacked any standing to do so filed a petition to appoint a special prosecutor, which was ultimately granted by Judge Tuman on June 21st, 2019. Now, we've challenged the authority of the special prosecutor in different forms. However, when the case came before Your Honor, we filed a motion to dismiss here. The reason that was relevant is because Your Honor needs jurisdiction over both the matter and the defendant in order to proceed against him. And with all due respect, Your Honor lacks jurisdiction and lacked throughout the entirety of these proceedings. And this is because Judge Tooman exceeded his authority when he appointed a special prosecutor, and that's for various reasons. Illinois courts do not possess inherent authority to appoint a special prosecutor in any given case. Rather, the limited authority to appoint a special prosecutor is derived from statute, and it allows the court to appoint a special prosecutor in only 3 discrete situations. The first is when the state's attorney is unable to fulfill her prosecutorial duties. The second is if the state's attorney has an actual conflict of interest in the matter. And the third is when the state's attorney files a petition for recusal. Now, Judge Tooman found that the first of these 2 were not applicable in this case, and he granted the appointment of a special prosecutor on the third scenario. However, there was no petition for recusal filed in this case, and that's an undisputed fact. In fact, when Sheila O'Brien filed her petition for appointment of a special prosecutor, State's Attorney Kim Fox came forward and she expressly and unambiguously stated that she did not intend to formally or legally recuse herself. But the court nonetheless concluded that what she intended was basically an unconditional legal recusal. Now, subsection A-15 of the statute authorizing the appointment of a special prosecutor doesn't contain a provision which says the court can infer or interpret from the state's attorney's actions whether the state's attorney intended to recuse herself. Rather, the provision is explicit that the subsection only applies when the state's attorney files an actual petition for recusal, which Kim Fox did not do in this case. Because the filing of a petition for recusal is an express statutory prerequisite to the appointment of a special prosecutor under subsection A-15, Judge Tooman exceeded his authority and violated the doctrine of separation of powers by usurping the role of the legislature and essentially redrafting the statute authorizing the appointment of a special prosecutor. Now, to compound matters, Sheila O'Brien also didn't have any standing to file the petition, and the court was not authorized to grant the appointment based on her petition. Now, the language in the special prosecutor statute is very clear as to who is allowed to petition the court for the appointment of a special prosecutor. The language is unambiguous and provides that only the court, the state's attorney, or a quote-unquote interested party may petition the court for the appointment of a special prosecutor. Now, what's an interested party? Well, according to Black's Law Dictionary, an interested party is, quote, the persons who take part in the performance of any act or who are directly interested in any affair, contract, or conveyance, or who are actively concerned in the prosecution and defense of any legal proceeding. Sheila O'Brien doesn't meet any of the requirements of that definition. Sheila O'Brien is a retired former judge who asserted her standing as a concerned citizen, somebody who was not satisfied with the way a duly elected official of Cook County decided to resolve a criminal matter, a low-level, nonviolent criminal offense, which they do every single day. But because of the high-profile nature of this case, she was not satisfied, and she decided to file a petition. So it's undisputed that she was not an interested party, but putting aside that fact, only the first 2 subsections, the 2 that Judge Tooman said are inapplicable, even allow an interested party to file such a petition. Those are the 2 sections that say the court either on its own motion or on the motion of an interested party. Subsection A-15, which is the one that Judge Tooman relied on in granting the appointment of a special prosecutor, doesn't say that you could appoint a special prosecutor based on the court's own motion or on the petition of an interested party. That subsection only permits the appointment of a special prosecutor upon the state's attorney's filing of a petition for recusal. It is undisputed that no such petition was filed in this case and that State's Attorney Kim Fox never intended to legally recuse herself. Therefore, it was completely exceeding Tuman's authority for him to grant the appointment of a special prosecutor at all. Now, he also misapprehended the law when he ruled that the informal recusal by Kim Fox rendered the entirety of the proceedings from Mr. Smollett's initial arrest all the way through the dismissal of the charges against him null and void. And none of the cases cited by Judge Tuman in his order actually support the court's conclusion that the proceedings against Mr. Smollett are null and void, that the prior ones were null and void. Rather, those cases, and particularly People v. Woodall, and that's 333 Ill App 3rd 1146, that's a 2002 case, makes clear that even if there had been a defect in the authority to prosecute Mr. Smollett, the only person who could properly challenge the validity of the proceedings would be Mr. Smollett, and he clearly did not do so. Now, separate and apart from the fact that the appointment of a special prosecutor was beyond Judge Tuman's authority, is the fact that Judge Tuman was not authorized to appoint a private attorney, which was Dan Webb and his law firm, Winston & Strawn, as the special prosecutors in this case. Subsection A-20 of the statute provides that prior to appointing a private attorney under this section, the court shall contact public agencies throughout the state to determine a public prosecutor's availability to serve as a special prosecutor at no cost to the county, and the key phrase here is shall appoint a public agency if they are able and willing to accept the appointment. The language in this subsection is mandatory and not permissive. Now, the defense is yet to see any proof that any public agencies whatsoever, including the ones specifically listed in the statute, were properly contacted about the potential appointment. Judge Tuman did represent that he contacted over 100 local public officials or agencies, and that he heard back from only around 30. But by Judge Tuman's own admission, at least 2 and possibly a 3rd public agency was willing to take on the appointment. However, without any explanation, Judge Tuman unilaterally decided that none of these 3 public agencies were quote-unquote able to do so, despite their representations to the contrary. The statute is very clear that the court shall appoint a public agency if they are able and willing to accept the appointment. It's only if after all public agencies have been exhausted and all are unable and unwilling to accept the appointment that the court can then appoint a private attorney, such as Dan Webb and his firm. There is no exception in the statute for private attorneys who might be willing to do the case pro bono or who are willing to do the case simply for costs, not charging for attorney's times, but for their costs, which for a firm like Winston & Strawn is probably still an astronomical amount. And I don't know what the total of the costs is. I know they were supposed to be filing reports with Judge Tuman, I believe every 3 months, to show the taxpayers what their prosecution of Mr. Smollett is costing in tax, and I'd be curious to see that figure. I'm not sure what that is, but I would guess it's a substantial amount. But regardless, that is not contained within the statute. And here, because multiple agencies apparently indicated their willingness and ability to accept the appointment, Judge Tuman exceeded his authority and again violated the separation of powers doctrine by usurping the role of the legislator and appointing a private attorney as the special prosecutors in this case. The next issue I'd like to address is that the instant prosecution against Mr. Smollett violated a contractual right to immunity that he was promised by the Cook County State's Attorney's Office. In the original criminal proceedings, there was an immunity-type non-prosecution agreement that was entered into between Mr. Smollett and the State's Attorney's Office as an agent of the people of the state of Illinois. Not only was this agreement agreed on between the parties, but it was actually executed and enforced by the courts. And it's something that's already been executed. This isn't something where they could renege because it's yet to be performed by either side, but this was actually executed by Mr. Smollett. And the state's promise to Mr. Smollett was that after he satisfied them as to his community service, after he forfeited his $10,000 in bail bond, that the state would not further prosecute him in connection with the January 29, 2019 attack on him. And here we are again in another case instituted, it might be by different attorneys, but it's on behalf of the state of Illinois. And there's a statute that controls, and that's section 5/114-1 of the Code of Criminal Procedure, and it allows the court to dismiss an indictment, and a court is required to dismiss an indictment where the defendant has received immunity from prosecution for the offense charged. And indeed, Illinois courts have consistently dismissed indictments that violate this section. And the courts here analyze informal immunity agreements under the same basic principles of contract law. So Mr. Smollett here performed his side, and he was entitled to the benefit of the bargain he made with the state's attorney's office on behalf of the state of Illinois, and that was violated. And in fact, the state's attorney's office, initially, they did perform their end of the bargain. They stood up in court in front of Judge Watkins, asked for the dismissal, and did what they had promised to do. And so at that point, the agreement was fully performed by both sides. The court enforced it, and there was absolutely no basis, and it was a violation of Mr. Smollett's rights to then re-prosecute him by the same principle, which is the state of Illinois. And there's important policy considerations for this, and the Starks Court, which is People v. Starks 106 Ill 2nd 441 1985, that's an Illinois Supreme Court case, and the Supreme Court in that case explained the significant policy considerations for this rule, and I quote, "The prosecution must honor the terms of agreements it makes with defendants. To dispute the validity of this precept would surely result in the total nullification of the bargaining system between the prosecution and the defense. Therefore, this court believes that if the prosecution did make an agreement with the defendant, it must abide by its agreement in this case." And there's one narrow line of exceptions that applies, and that's in an event of a plea agreement. Obviously, there was no such plea agreement in this case, and Mr. Smollett's present case fits squarely within Starks, and his due process rights have been violated as a result of the instant indictment because he was promised not to be hauled back into court, and that's exactly what happened here. And aside from having to face a second prosecution, he faced all of the things that are attendant with that, from the expense and emotional turmoil and everything else that the second prosecution has entailed. In short, Mr. Smollett relied on the representations by the Cook County State's Attorney's Office, and at the end of the day, a deal is a deal, and the state of Illinois is not exempt from that ancient principle. And so we would ask that the case should have been dismissed on that basis. Now, the next issue I'd like to address is the double jeopardy. And we had briefed this before. The court's very familiar with our position on this, but just in brief to highlight a few of our points. The double jeopardy clause does not just prohibit double prosecutions, it also prohibits double punishment. And to punish somebody twice for the same thing is a violation of the Fifth Amendment. And here, Mr. Smollett was clearly punished in the prior criminal proceedings by the imposition of a criminal penalty. Now, certain people may disagree with the severity of that punishment. They may not think that was a just result, but it doesn't take away from the fact that he was criminally punished. And even the Office of the Special Prosecutor, at the outset of the case, when they filed the new indictment, they issued on February 20th, 2020, something called an information release. And in that information release, Dan Webb himself acknowledged that Mr. Smollett had been punished during the prior criminal proceeding. And I quote him when I say that Mr. Webb stated that the only punishment for Mr. Smollett was to perform 15 hours of community service and requiring Mr. Smollett to forfeit his $10,000 bond as restitution to the city of Chicago. Those are Mr. Webb's words, not mine. And he said the only punishment. So he acknowledged that Mr. Smollett had been punished. But again, he wasn't satisfied with that punishment. And that's exactly what the double jeopardy clause is meant to prevent, second guessing of one prosecutor's discretion by another prosecutor. And that's exactly what happened in this case. There was absolutely no rational, non-punitive reason for Mr. Smollett's $10,000 bond forfeiture other than to serve as punishment. Upon the dismissal of the case, his bond normally would have been returned to him, less any bail costs, which would not exceed $100. However, despite Mr. Smollett's full compliance with all bail conditions, the forfeiture of his bond was required as a condition of the dismissal of charges against him. Therefore, this was obviously intended to punish him and serve deterrent purposes. And finally, the fact that he was not convicted of any crimes in the initial prosecution doesn't affect the analysis. In a case decided over 140 years ago, the United States Supreme Court explained, and I quote, "The compromise pleaded must operate for the protection of the distiller, in that case, against subsequent proceedings as fully as a former conviction or acquittal. He has been punished in the amount paid upon the settlement for the offense with which he was charged, and that should end the present action, according to the principle on which a former acquittal or conviction may be invoked to protect against a second punishment for the same offense. To hold otherwise would be to sacrifice a great principle to the mere form of procedure and to render settlements with the government delusive and useless. And for those reasons, the indictment against Mr. Smollett should have been dismissed for violation of the double jeopardy clause." And so, again, here we are at following a trial, and we should have never been here to begin with. There were various critical errors that permeated these proceedings, and the charges against Mr. Smollett and the second indictment should have been dismissed at the outset. Respectfully, Your Honor does not have jurisdiction over this matter, and we believe it was legal error to proceed. Now, the second category of errors I'm going to discuss are trial-related errors. And these errors began from the outset of the trial, beginning with jury selection, and they went all the way through closing arguments and even jury deliberations. And again, I'm not going to go through all 13 of the errors that we outlined in our papers, but I will highlight some of the critical ones that violated Mr. Smollett's constitutional rights. I think everyone can agree that this was one of the most high-profile cases in recent history. There was an immense amount of prejudicial pretrial publicity and an overwhelming presumption of Mr. Smollett's guilt long before a single piece of evidence was ever presented in a court of law. And this was in part due to a national press campaign by the former police superintendent, Eddie Johnson. And he went on national television on various networks, and he made blatantly false allegations of what the evidence in this case was. And there were three in particular, and these issues were never raised at trial because that's just not what the evidence was. Eddie Johnson went on TV and he said Mr. Smollett did all of this because he was dissatisfied with his salary on Empire. That was completely a false assertion. That there was zero evidence of that whatsoever. But he went out there and said that and put that in the potential jury pool. He also said that Mr. Smollett had sent himself the letter. Mr. Smollett fully cooperated. He gave his DNA, he gave his fingerprints to the FBI, not to CPD, but he did that to the FBI, and there was no connection between him and the letter. That didn't prevent Eddie Johnson from going out there well before this case ever got to trial and tainting the jury pool with that false assertion. He also said that Mr. Smollett paid the brothers $3,500 for the attack. And it was the brothers' own attorneys who went on TV right after that and said, no, this was actually as corroborated with a lot of text messages between Jussie and Abimbola Asundario. He had hired Abimbola as his trainer, and that's what the $3,500 check was in fact for. Now, based on this overwhelming presumption of guilt in this case, it was critical that jury selection be fair so that Mr. Smollett would receive a fair trial if that was even possible. But there were fundamental errors in that process. First, the court violated Mr. Smollett's Sixth Amendment rights by preventing the defense from actively participating in the voir dire process. The defense sought to directly question the veneer, but the court denied that request. And although the court asked the parties and took questions from both sides as to certain questions that should be asked of the potential jurors, Your Honor didn't ask all of the questions that the defense requested. By refusing to allow the defense to meaningfully participate in the voir dire process, the court prejudiced the defendant's ability to discover those members of the potential panel with biases and or potential prejudices against Mr. Smollett, violating his Sixth Amendment rights. Although the court repeatedly stated that you didn't want to treat this case any different than other cases, this was an abuse of discretion in this case because of the prejudicial pretrial publicity, which could not be ignored.
Ms. Landon, do you think I was required to ask every question submitted by your team to the veneer, every single one?
We think we should have been allowed to participate in this process because of the unique circumstances of this case where there was such an overwhelming presumption of guilt. We think it's a very different process when the court asks questions and when we as attorneys get to ask the right follow-up, in real time without having to wait for. There were certain questions the court asked, and this was my next point with Rosemary Mazzola, where the court cut off the answers.
I think I asked most of the questions the defense requested of me. There were some I did not. For example, you wanted me to ask the veneer, what kind of animal would you like to be if you had to be an animal? Or Superman or Batman, what do you prefer? Do you really think I was supposed to ask a veneer when I'm choosing a jury in a criminal case, those kind of questions?
We identified certain questions in our motion that we think, I believe there were 4 questions that we thought were critical, not the ones Your Honor just mentioned, but there were important.
That was part of the pool of questions I received from you.
Right, but there were important questions that were not asked, and the more significant factor is we should have been allowed to question the veneer in this case. Again, I'm not saying in every case. I respect that Your Honor doesn't do that in a lot of other cases. However, this case is obviously unique. Mr. Smollett, unfortunately for him, has not been treated like anyone else charged with Class 4 felonies. He's been disadvantaged at every turn, and his jury selection
I pick a jury in this case the same way I pick a jury in a murder case. I do the questions. I ask the lawyers for input. Tell me what questions you want me to ask. I vet them. And I'm happy to ask the questions that are relevant and helpful.
I understand, Your Honor.
But just the only point I'm trying to make is that I absolutely treated him the same as everybody else. And I didn't distinguish him from a Class 4 offender or potential offender from a person accused of murder.
I understand, and I think, Your Honor, that's the problem here. A regular murder defendant doesn't walk into court with a presumption of guilt. Mr. Smollett did. There is a presumption of innocence. That was non-existent in this case, and that was due in large part to, as I said, the former police superintendent held a press conference. He went out and did a media campaign. The mayor spoke out on this case. Even Judge Tooman, in his order, before a single piece of evidence had been set forth before Judge Tooman, he convicted Mr. Smollett in his order. He talked about what a charade this was, and he made findings, and Judge Tooman should have been recused. We actually filed a motion for him to recuse himself because based on the face of the order, it was clear that he harbored bias against Mr. Smollett and was convinced of his guilt when he was not ruling on a motion that involved there was no factual dispute before him. There was no evidence presented to him. And he nonetheless took it upon himself to make improper factual findings which evidenced his bias. He should have recused himself. However, he didn't even let us intervene in those proceedings to consider our motion for recusal and to consider our motion for reconsideration of the order appointing the special prosecutor, and all of that was error. But to Your Honor's point, the reason I think Your Honor should have treated this case differently is for all the reasons I stated, which is he does not sit and he did not come before Your Honor the same as other defendants with a presumption of innocence, which is what he is afforded and entitled to under the Constitution. Instead, he walked in. I've never seen presumption of guilt the way Mr. Smollett faced. And it deprived him of a fair trial, and the court should have taken precautionary measures during jury selection. There should have been more leeway in this particular case. We made that request, and with all due respect, we believe it was error for the court to deny our active participation in the voir dire process and to ask the questions that we thought were important to be asked. Now, turning to a specific juror, which was Rosemary Mazzola, we specifically asked the court in chambers to further inquire of Ms. Mazzola, since she had told open court, said in open court, that pretty much her entire immediate family are either current or former law enforcement. And there had been no follow-up to ascertain the fact as to whether Ms. Mazzola may have a family member who is actually involved in the investigation of Mr. Smollett or any of the facts surrounding his case. And we brought that to the court's attention. We thought that was a critical question that should be asked, because if we knew one of her relatives, for instance, was involved and helped investigate this case or was partners with someone who was investigating this case, that would have been critical, and obviously she should have been removed for cause. The court denied our request, and we don't think there was any good basis not to bring Ms. Mazzola in and ask her these important questions to make sure that she is unbiased and that she did have no personal conflict. And in fact, several times when Ms. Mazzola was answering the court's question, Your Honor interrupted her, and we don't actually know what she was intending to tell the court and the parties. And for all those reasons, we think that the jury selection process, and the other reasons obviously outlined in our motions, was flawed, and that a new trial must be granted. We also outlined in our papers the improper denial of several Batson motions in response to the Office of the Special Prosecutor's peremptory challenges, which we believe were improperly used to remove jurors based on their race and sexual orientation. Now, I'm not going to detail each of the peremptory challenges that we've outlined in our papers, but in short, anybody looking at this jury can tell that it was not a jury of Mr. Smollett's peers in Chicago. And we think that these significant issues during jury selection deprived Mr. Smollett of his constitutional right to a fair trial, and the remedy is to grant him a new trial. I'm next going to address the issue of prosecutorial misconduct. And this relates to an independent eyewitness, Anthony Moore, who was working as a loss prevention officer for the Sheraton on the night Mr. Smollett was attacked. Now, Mr. Moore does not know Mr. Smollett personally. He was a completely independent witness that police on their own interviewed multiple times. And Mr. Moore spoke to the detectives on at least 3 occasions, including on February 2nd, 2019, and on February 27, 2019, at Area Station. On each of these occasions, Mr. Moore unequivocally told police that around 2 a.m. as he was doing his rounds at the Sheraton, he saw 2 men running towards him from the area where the attack occurred. He said he flashed his flashlight on the first man's face, and he saw a white male wearing a ski mask. Mr. Moore could not see the second man's face. And Mr. Moore was entirely consistent with his repeated descriptions, and he never expressed any doubt as to what he saw. In fact, when asked to view a photo lineup at the station with only black men included, Mr. Moore told officers that the man couldn't be in the lineup because the man he saw was white. This description of a white male wearing a ski mask was exactly what Mr. Smollett had seen and described to officers. Mr. Moore was a key defense witness, as his testimony provided at the very least reasonable doubt that Mr. Smollett was truthful in his account of what he saw that night. Now, a year later, on January 29th, 2020, prosecutors from the Office of the Special Prosecutor met with Mr. Moore for a lengthy period of time, and they chose not to video record this interview. At trial, Mr. Moore testified that at this meeting, they showed him the CPD's evidence against Mr. Smollett, including surveillance footage and pictures of the Osendario brothers, who they said were Mr. Smollett's attackers. Mr. Moore testified at trial that he felt, quote-unquote, pressured and threatened to say he saw something he didn't see. And exhausted after hours of telling prosecutors something they did not want to hear, he eventually signed a statement saying he could have been mistaken when he saw a white man because maybe when he flashed the flashlight on his face, it was the reflection from the light that made him think that the individual was white. There was absolutely no reason for the Office of the Special Prosecutor to try to taint an independent eyewitness's clear memory of an event by showing him their version of the evidence and trying to scare him that he would be committing perjury if he testified consistent with his own independent memory of what he saw. This form of intimidation constitutes egregious prosecutorial misconduct and violates Mr. Smollett's fundamental right to present witnesses in his defense. By having Mr. Moore change his statement in writing, not only did the Office of the Special Prosecutor try to disqualify Mr. Moore as an exculpatory defense witness, they actually tried to obtain false, incriminating evidence against Mr. Smollett. Although Mr. Moore, on the stand, tried to explain the reasons he gave the written statement stating he could have been mistaken about the skin color of the man he saw, the prosecutorial misconduct inevitably discredited Mr. Moore, and this flagrant misconduct constitutes reversible error. Now, the OSP's argument on this issue is really, it's the adage, the best defense is a good offense. They claim in their papers that the defense engaged in gamesmanship and, quote, manufactured prosecutorial misconduct. More outrageously, they claim that Mr. Moore committed perjury when he told the truth. This is belied by the undisputed record, which is that Mr. Moore gave police consistent accounts of what he saw, which is a white man wearing a ski mask, on multiple occasions close in time to the incident. Now, although the Office of the Special Prosecutor presumes that the defense was aware of this prosecutorial misconduct prior to trial, that's simply a false assumption on their part. While Mr. Moore had been identified as a potential defense witness from the start based on his exculpatory statements to police, we only interviewed Mr. Moore for the first time on Friday, December 3rd, just days before he gave his testimony that Monday. And there was no statement to provide to them pursuant to Rule 413D. We had him on our witness list as a potential witness. As Your Honor knows, the defense never knows until well into the trial whether you're even putting on a defense case. We knew he had always consistently said he saw a white male, so that's why he was on our witness list. And the decision was made mid-trial that we did want to, in fact, pursue calling him as a defense witness, and we spoke to him briefly. We interviewed him to see why he changed his statement, because it had been very clear that he consistently said one thing, and then a year later, after meeting with the special prosecutors, changed his story a little bit. He was careful in how he did it. He didn't say, I'm wrong, but he said, I may have been mistaken, because, again, he wanted to be truthful. And the special prosecutors now say, oh, this was perjury, and the defense suborned perjury. Nothing is farther from the truth, and if the OSP actually believed that, they would have cross-examined him on what happened actually during these meetings. Not only would they have cross-examined him, they could have put up a witness to impeach him who was present during that meeting to say, actually, that's not what happened. They didn't do either of those things. And of course, they could have charged him with perjury, but they won't do that because he was not lying and he was telling the truth. One way or another, this was an egregious violation brought by the Special Prosecutor's Office. They should have been disqualified when we made the request, and a motion for a new trial is required on that basis. And unfortunately, this isn't limited to Mr. Moore. Shortly after, for the second grand jury, when the Special Prosecutor's Office convened the special grand jury to proceed on the second indictment against Mr. Smollett, they had at that time our papers that we had submitted to Judge Tooman asking him to reconsider the order granting a special prosecutor. And what we had done is detail the evidence, the favorable evidence, showing that Mr. Smollett was not guilty. And the OSP went to every single favorable defense witness. They didn't call any of them as live witnesses before the grand jury, where the grand jurors could potentially ask them questions. What they did is they went to each of them, and every favorable witness somehow changed their account and submitted a statement consistent with the state's theory, even though that was not their original statements 1 year prior. And there were witnesses who suddenly we couldn't contact anymore, who went missing. This was a real issue in this case. And Mr. Moore was just a prime example of that. Another example was David Alegbe, who similarly had said that he had seen the passengers in his Uber speaking on a cell phone. That wasn't convenient for the prosecution's case because the brothers testified that they didn't have their cell phones with them. And there were two witnesses actually who had said this. There was an independent taxi driver who said one of the brothers was texting during the drive, and separately David Olegbe, who said one of the brothers was on the phone. Now, of course, after we had set that in our papers, OSP talked to David Olegbe and got him to write a statement saying he may have been mistaken about the phone use because it was inconsistent with their theory of the case. And Your Honor saw David Olegbe got on the stand and he explained not only did he hear one of them speaking on the phone for 1 or 2 minutes before the second brother got in the car at their house, which they tried to say he could have been rehearsing his acting lines for that evening, as if the profanities that was yelled at Jussie in the street would have been something that would have to be rehearsed out loud in an Uber. But separate from that, Mr. Olegbe said that halfway through the drive, they changed the destination in the app, which could only be done with the use of a cell phone. And that was not contained in a statement. That was never any of the OSP's disclosures to us. That was something we learned for the first time actually at this trial when Mr. Olegbe testified. In short, we think there were significant issues with the way the OSP treated this case with the defense witnesses, and they tried to have defense witnesses either take back their statements and give incriminating statements towards Mr. Smollett, which were not their original independent stories, or I suppose some of these witnesses, for inexplicable reasons, were just not available, for the defense to reach. So we think certainly a new trial is warranted based on all of these errors, but particularly on Mr. Moore and his statement at trial that he was threatened and pressured by the OSP to change his truthful testimony, which was exculpatory for Mr. Smollett. Next, I'd like to address the burden shifting. The OSP improperly shifted their burden to the defense on 3 different occasions during the trial. As the court well knows, it's entirely the prosecution's burden of proof, and it's reversible error to try to shift this burden to the defense at any point during the trial. And this happened first during the questioning of Detective Thies, then during the questioning of Abimbola Asundario, and again in the state's rebuttal argument, which was the final word the jury heard from any lawyer prior to retiring to deliberations. The seminal case on a prosecutor's improper comments on a defendant's post-arrest silence is Doyle v. Ohio, and that's 426 U.S. 610, 1976 case, which holds that it is a deprivation of due process to allow an arrested person's silence after that person has been Mirandized and advised of his Fifth Amendment right to remain silent, to then use that silence against them at trial to create an inference of guilt. And that's exactly what the OSP did here on 3 separate occasions. Now, in its opposition papers, the OSP tries to argue that their questions to Detective Thies and to Abimbola Asundario relate to a text message sent on February 14, 2019, and do not involve Mr. Smollett's post-arrest silence. However, the improper questions were not limited to the text message or even to the time period prior to Mr. Smollett's arrest. For example, in questioning Detective Thies, Mr. Mendenhall broadly asked, quote, did he, meaning Mr. Smollett, ever make a statement that they, referring to the Asundario brothers, did nothing wrong and never would? Answer, no. Question, to this day, has he ever come clean about this hate crime that you are aware of? Answer, no. This questioning indisputably violates Doyle, as it necessarily includes Mr. Smollett's post-arrest silence. Furthermore, Illinois law actually goes a step further by holding that it's impermissible to impeach a defendant with his or her post-arrest silence, regardless of whether the silence occurred before or after the defendant was given Miranda warnings. In its opposition papers, the OSP argues that the defense did not object to this line of questioning. However, the OSP's improper burden shifting constitutes plain error affecting Mr. Smollett's substantial rights, for which a lack of an objection is not fatal. Similarly, during the direct examination of Abimbola Asundario, Dan Webb asked him whether Mr. Smollett ever made a statement to the public where he admitted that the hate crime was a hoax. The defense did object to this question, and the court sustained the objection. Similar to Mr. Mendenhall's questions, which were not limited to the text message or even to the time period prior to Mr. Smollett's arrest, Mr. Webb's question is equally problematic. Now, the OSP argues in its opposition papers that the word statements to the public somehow makes Doyle inapplicable. This argument is frankly ridiculous, as any public statements by Mr. Smollett would have been used against him if he testified at trial, the same as if he had made those statements to police. Here, this entire case hinged on the credibility of Mr. Smollett and of the Osundario brothers. By improperly commenting on Mr. Smollett's failure to tell the police or the public that the Osundario brothers did nothing wrong or to quote-unquote come clean, the OSP violated Mr. Smollett's due process rights and his Fifth Amendment right to remain silent by improperly trying to shift the burden of proof to him. The OSP engaged in further burden shifting during its rebuttal argument, which was particularly prejudicial because it was the last time the jurors heard from any lawyer in this case. During rebuttal, Mr. Mendenhall stated, quote, "Mr. Uche gave you no evidence of any video that was missing." The court overruled the defense objection, which was error. In its opposition papers, the OSP tries to minimize this error by arguing that this was simply a single comment and that it was provoked because defense counsel had argued to the jury that there was a lot of missing data. But that's the prerogative of the defense to argue. Again, it's the state's burden. They put on a lot of surveillance video and they suggested to the jury that they had a complete account from the beginning of the night to the end of the night, and the jury had to be told that these were pieced together, but there was a lot of missing footage. It was proper for the defense to do that. However, it was not proper for the prosecution to put that burden on the defense and ask for the defense to produce the missing surveillance footage, which is simply, again, not our burden to do. And as the court well knows, a single comment is sufficient to constitute reversible error warranting a new trial. And we had cited in our papers the case of People v. Giangrande, and that's 101 Ill App 3rd 397. It's a 1981 case, and that's instructive. That also involved a single comment by the prosecutor in the closing remarks, and the remark was, "Where's the evidence?" And as the court explained in that case, the comment may well have improperly suggested to the jury that defendant had a burden to introduce evidence. Objection to it was overruled by the trial judge. This was error. And again, it was error in this case for them to make that comment and for Your Honor to overrule that objection. And we ask that a new trial be granted on that basis. And I'm going to turn lastly to the accomplice instruction. The court in this case committed reversible error when it refused to provide Illinois Pattern Jury Instruction number 3.17 entitled Testimony of an Accomplice with regard to the Osundario brothers' testimony as requested by the defense. Pattern Instruction 3.17 provides, quote, "When a witness says he was involved in the commission of a crime with the defendant, the testimony of that witness is subject to suspicion and should be considered by you with caution. It should be carefully examined in light of the other evidence in this case." Now, despite the title, the instruction is not warranted only where a witness is officially charged as an accomplice. Rather, Illinois courts have held that the defendant is entitled to have Instruction 3.17 given to the jury if the witness, rather than the defendant, could have been the person responsible for the crime, or if the witness admits being present at the scene of the crime and could have been indicted either as a principal or under a theory of accountability, but denies involvement. Here, both of those circumstances are present, which required giving the accomplice witness jury instruction. The Osundario brothers were initially arrested because the CPD had not only probable cause, but substantial evidence that they were the perpetrators who attacked Mr. Smollett on January 29, 2019. And since then, in statements to the CPD and sworn statements to the grand jury and at trial, the Osundario brothers admitted to doing everything Mr. Smollett told CPD they did. Confront him on the street, yell racial and homophobic slurs at him, punch him, kick him, pour bleach on him, and put a rope around his neck. If it was not for their own self-serving statements and testimony, that they did all of the above acts at Mr. Smollett's behest, they would have been charged with a hate crime, or at least a battery against Mr. Smollett. Because the Osundario brothers could have been the persons responsible for the attack on Mr. Smollett, pattern instruction 3.17 should have been given to the jury. Furthermore, assuming for the sake of argument that the Osundario brothers were in fact acting at the direction of Mr. Smollett as they alleged at trial, the only reason they were not charged as either co-conspirators or accomplices for their admitted participation in the attack on Mr. Smollett is because of their self-serving statements that they didn't know that Mr. Smollett would report the attack to the police. They asked the jury to believe that the elaborate, staged attack was solely for the media's benefit, taking the absurd position that somehow a heinous crime against a high-profile celebrity, which was supposed to be caught on camera, would not result in a police investigation. Because the Osundario brothers admitted being present at the scene of the attack and could have been charged either as principals or under a theory of accountability, pattern instruction 3.17 should have been given to the jury. Now, the
Charged with what?
Well, Your Honor, they could have been charged with filing a false conspiracy to file a false police report. They could have.
There was evidence that they were part of filing a false police report?
Your Honor, there's so much law out there that you could file. There was certainly probable cause to charge them with being an accomplice to Mr. Smollett. Had they not participated, there would be you can't file a so-called false police report if there had been no attack. So clearly they were accomplices, clearly they were co-conspirators. Now, they weren't charged because they took the convenient position. We knew everything until the final step, which, was convenient. And obviously, in any other case, if there were other witnesses, I guarantee the brothers would have been charged. The only reason they weren't charged in this case was because the police needed them to prosecute Mr. Smollett. Without them, there was no case against Mr. Smollett, because as the court saw, there is not a single piece of independent evidence that shows that Mr. Smollett perpetrated a hoax, planned a hoax, or anything else. The only connection, and keep in mind, they subpoenaed, or they got a search warrant for 1 entire year of Mr. Smollett's cell phone data, location, text, voicemails, all sorts of communications. They couldn't find one thing that supported the fact that Mr. Smollett planned this. All they had was the brothers saying, after they got caught, after they were in custody for 47 hours, after they had been consulting with an attorney who was speaking to both of them, after that attorney showed them his Good Morning America video while they were in custody and they heard every single thing Mr. Smollett was saying, they conveniently turned around and said, oh yeah, you're right, we did do this, but it's because Mr. Smollett asked us to. And it was their own attorney who said she didn't say she gave a radio interview, she didn't say they came clean, she said, I pieced together what happened. I looked at the timeline, I looked at the CPD's evidence, and I put together a timeline of what happened in this case. And it's our belief that that story was spoon-fed to the brothers and that that's the story that they gave police, which allowed them to be released from custody, uncharged. They became the star witnesses, and they've tried to capitalize on this whole regrettable incident. So we had cited the court to People v. Carrion, and that's 162 Ill Act 3rd, 990, 1987. And that's one of the cases we cited in which the trial court's refusal to give such an instruction constituted prejudicial error requiring a new trial. Now, in their papers, the OSP doesn't address or attempt to distinguish this case because there really is no distinguishing factor, and that case is instructive. In that case, the court held that the trial court erred by refusing to give a caution. Notwithstanding his profession of innocence based on his alleged fear of the defendant, we believe probable cause existed to indict Amaya for the offenses, particularly when one considers that when he was initially taken into custody for questioning, he possessed money linking him to the crime. And in that case, the appellate court held that it couldn't find that the failure to give the requested instruction constituted harmless error especially in light of the fact that Amaya's testimony was the only direct evidence implicating Carrion. And it's the same reason why giving this instruction was critical in this case, where the evidence against Mr. Smollett was far from overwhelming. I know the police department put on a long narrative, a lot of surveillance footage, but all that evidence was consistent with Mr. Smollett's testimony of his actions. He never denied seeing the brothers on the occasions where they went to great lengths to show, oh, on the 25th he drove to the brothers' apartment. He admitted that. On the 27th he, met with the brothers. These are not things that were disputed. So that's not overwhelming evidence of his guilt. There were different interpretations of what that evidence actually meant. And the only direct evidence implicating Mr. Smollett was what the Osundario brothers said. And it was reversible error not to instruct the jury that they had a motive to lie about that testimony. It was that story that allowed them to avoid charges in a case where a convicted felon engaged in an attack on Mr. Smollett. He and his brother, if you believe the testimony, agreed to do this despite Ola's prior criminal felony conviction for a very similar attack on another individual, another group attack. But for all of that, it was really their own testimony that's the only direct evidence implicating Mr. Smollett. So under the circumstances of this case, the court should have instructed them that their testimony should have been cautiously scrutinized by the jury. And the court's refusal to provide this instruction under the circumstances of this case was not harmless and constitutes reversible error. In conclusion, I'd just like to say that although we believe each of the 13 errors outlined in our papers independently constitute reversible error and that each warrants the granting of a new trial, even if the court is not persuaded that any one of these errors warrants a new trial, we believe that the totality of trial errors undoubtedly affected the verdict, and the cumulative error certainly warrants a new trial. And there's ample authority supporting the grant of a new trial in such cases, and I'll just cite the court to People v. Lettrich, and that's 413 Ill 172. It's a 1952 case where the Illinois Supreme Court reversed the defendant's murder conviction and death sentence. In that case, there were a number of evidentiary errors alleged, including that the court erred in limiting and restricting the defendant's cross-examination of a critical witness, as well as certain inflammatory and prejudicial remarks to the jury in the arguments by the state's attorneys. In reversing the conviction and sentence, the Illinois Supreme Court stated that the totality of these errors compel us to the conclusion that this defendant has not had the fair and impartial trial, which is the inherent right of every person accused of a crime. And that's the same exact situation we have here. There have been a series of legal errors. If the court is not convinced that any one of them warrants a new trial, we'd ask that the court consider the totality and grant Mr. Smollett a new trial.
Thank you, counsel. The government wishes to make response to the post-trial motion of the defense.
We do, Your Honor.
Mr. Weaver, you may address the court.
May it please the court.
Counsel.
Your Honor, due to the sheer volume of the arguments heard about an hour here, and you've already mentioned the 83 pages that they've submitted, my partner and fellow Deputy Special Prosecutor Sam Mendenhall have bifurcated the opposition. I'll give an overview, and based on Ms. Gladian's presentation, I'll highlight 4 alleged errors. I believe Mr. Mendenhall will have a couple. To begin, I'll just start with a blanket statement that for everything prior to November 29, 2021, going backwards to 2019, for the alleged errors that they've incorporated by reference in their papers and the preamble to Ms. Gladian's presentation, we universally disagree that there is any error in those prior rulings, and we too, in our opposition and here today, will incorporate by reference our prior responses, briefs, colloquies with the court, arguments presented over the last couple of years on all those issues. And I will not retread them, but the record is clear for the issues that have been presented to Judge Tooman, for which we have been involved, for the issues that have been presented to this court, for which we have been involved, and for the issues that have been presented to the Illinois Supreme Court, for which we've been involved, are all incorporated by reference. At each stage, no matter the court or the judge that have heard it, each one of those prior rulings were proper, required by the law, and none need be nor should be revisited. And since Ms. Gladian brought it up, it probably is a good reminder that my firm of Winston & Strawn and the partnership did take this case pro bono. And our firm did, and Mr. Webb in particular, did shoulder that burden that was called for by the appointment of the special prosecutor. And we did so the entirety of the attorney time free of charge. Not a dime. Limited expenses in the normal court. Judge Tooman's order did allow, and these are things such as court reporter fees, transcript fees, copying fees, those same fees that would exist for the Cook County State's Attorney's Office are expenses for which have been submitted to the county for reimbursement. But they are minor compared to the amount of free service that our firm of Winston & Strawn has given to this county and to the citizens and to the judicial system. Mr. Webb's appointment in particular as a special prosecutor would stem from Judge Tooman's 2019 June order in order to restore the public's confidence into the integrity of the criminal justice system, was answered by our firm, was answered by Mr. Webb, and you might just recall the two directives that required. The first directive to determine whether Mr. Smollett should be further prosecuted. That's what we're here for today. But it shouldn't be forgotten, and I don't believe is, but it's worth remembering that the second directive, whether any person or office involved in the initial Mr. Smollett case engaged in any wrongdoing, our office also did that. And you heard Ms. Gladian talk about certain of those things in her argument, but the OSP did complete a thorough investigation, did have a grand jury seated, did prepare a detailed and comprehensive report as it relates into the Cook County State's Attorney's Office, as it relates to the investigation in the Chicago Police Department, and did so for a total cost of attorney times for $0.00. And it should be noted, since it was raised, and it's important to understand that we believe we have fulfilled the call to restore the public's confidence into the integrity of the criminal justice system. As to the actual substance of Ms. Gladian's presentation, and as it relates to the 13, what I'll call macro-level alleged errors, although they list a myriad of alleged sub-errors as well. The evidence presented at trial, Your Honor, overwhelmingly established Mr. Smollett's guilt beyond a reasonable doubt. And that's reflected in the jurors' unanimous guilty verdict. And nevertheless, Mr. Smollett asked this court for extraordinary relief to overturn the jury's verdict that found him guilty of 5 serious felonies of making false police reports. And in doing so, he raises a variety of alleged procedural, alleged evidentiary errors, both pre-trial and during the trial itself, committed by anyone and everyone involved in this case, except, of course, Mr. Smollett himself or his lawyers. just a few examples. He's blamed the prosecutors. He's blamed Your Honor specifically. He's blamed your courtroom staff. These are in his papers. He's blamed the Cook County sheriffs in this courtroom. He's blamed the entire Cook County judicial system. He's blamed the Illinois Supreme Court. He's blamed COVID-19. He's blamed the media. He's blamed, quote, political figures. He's blamed witnesses at trial. And he's even blamed the jury itself. Page after page after page of finger-pointing and scapegoating. But once that bluster and hyperbole, Your Honor, is excised from that motion, and the examination of the real underlying record is undertaken, it clearly reveals that each of the alleged errors is, one, meritless. Two, it is riddled with distortions of the actual record. And three, frequent misapplication of controlling Illinois law. But most important, none of those alleged supposed errors remotely would rise to the level of, one, requiring overturning the jurors' unanimous verdict, nor two, the issuance of a new trial. As it relates to the alleged errors where Mr. Smollett seeks a judgment notwithstanding the verdict, here's what you didn't hear. You did not hear what the law actually says and what you'll have to weigh today. So I'm going to give it to you. Illinois law mandates that a judgment of acquittal is only appropriate when, quote, a trial court concludes, after viewing all the evidence in the light most favorable to the state, that no reasonable juror could find that the state had not met its burden of proving the defendant guilty beyond a reasonable doubt. And, quote, a motion for judgment notwithstanding the verdict should be granted in instances only where the state's evidence, when viewed in the light most favorable to the state, is insufficient to support a finding or verdict of guilty. Here, Mr. Smollett has not met and cannot meet the incredibly high standard for overturning the jury's verdict, and when viewed in the light most favorable to the state, that's the OSP in this instance, the evidence presented during the almost 2-week trial overwhelmingly, beyond a reasonable doubt, demonstrated that Mr. Smollett devised, orchestrated, carried out a fake hate crime, and then, in violation of Illinois law, repeatedly reported that fake hate crime to the Chicago Police Department as a real hate crime. And the plethora of evidence, just heard Ms. Gladian say, not a lot of evidence, or certainly not a lot of independent evidence. Here's a summary. The testimony of 5 Chicago police detectives and officers. The jurors heard the testimony of the Osendero brothers. The jurors heard cross-examination by the defense of each of those witnesses. The jurors received into evidence over 40 exhibits, including phone records, text messages, social media evidence, video surveillance, GPS evidence, receipts, and a $3,500 check written by Mr. Smollett to the younger Osendero brother. They heard the testimony of the defendant's 6 witnesses, and they heard Mr. Smollett himself. Hours and hours and hours worth of the defendant's own testimony. All that evidence, when viewed in the light most favorable to the OSP, it simply cannot be said with a straight face that no reasonable juror could find that the OSP did not meet its burden in proving Mr. Smollett guilty beyond a reasonable doubt. That's for the JNOV portion. As it relates to the remaining alleged errors that do not go to the sufficiency of the evidence at the trial, that's when they say that those are more appropriate, perhaps, for a motion for a new trial. Illinois law tells us that a post-trial motion for a new trial is a matter for the trial court's discretion. Because none of the alleged trial errors you've heard or seen in their papers have any merit, this court should exercise its discretion and deny Mr. Smollett's alternative relief for a new trial. As it relates to the 4 errors I alluded to, Your Honor, that I just want to give a counter-narrative to, since they were raised. 3 were raised. That's on the voir dire issue, the Bassin issue, the accomplice instruction, and then I think it's also important to briefly touch upon one written about but not discussed here, which is the concept of the violation of his public trial rights. I'll just go in the order. Alleged error as it relates to the voir dire. The court's voir dire process was plainly consistent with Illinois law and consistent with Rule 431. Notably, defense counsel didn't raise any objection at trial as it relates to the actual conduction. The rule's language, as the court deems appropriate in Rule 431, makes clear that the decision as to whether to allow direct questioning is entirely within this court's discretion. Per Rule 431, the court conducted voir dire by directly questioning the prospective jurors, but consistent with Rule 431, the court exercised its discretion and allowed the parties to submit voluminous questions to be asked during the voir dire. Both sides. Both the OSP and the defense submitted rather voluminous supplemental questions for further inquiry of prospective jurors. Pre-trial, you reviewed those very thoroughly. We had colloquies on them. We had hearings on them. We had exchanges on them. Defense counsel ultimately submitted nearly 60 supplemental questions to ask during voir dire. The court took input, and importantly took input from the parties throughout the voir dire process, both at sidebar, in chambers, pre-trial, and during trial. And those additional follow-ups were often asked of the prospective jurors, and when they were not, the court explained why. In Your Honor's discretion, they would not be asked. No prejudice exists. Defense counsel was permitted to question the prospective jurors through the extensive supplemental questions, through the extensive supplemental questions that they submitted pre-trial, and through the supplemental requests that occurred during trial. Alleged error number 2, the Batson challenges. And I'll begin by noting unequivocally, the accusation that the OSP engaged in, quote, a systematic pattern of discriminatory challenges, end quote, is absolutely meritless. Lobbying unfounded accusations of jury discrimination that are belied by the actual record is unfortunately completely consistent with Mr. Smollett's attempts to interject and weaponize race and sexual orientation into these proceedings more generally. Just as he did when reporting the fake hate crime to the Chicago police in 2019, just as he did when he took to the airwaves in 2019 in what is now perhaps the now infamous Good Morning America interview. The court heard defense motions made under Batson versus Kentucky as to the OSP's use of his peremptory strikes. Those occurred in chambers on the record. And when such motions were made, as Your Honor knows, under the Batson case, but also under Illinois law in People versus Davis, the defendant must first make a prima facie showing that the prosecutor has exercised peremptory challenges on the basis of race. And the court correctly concluded at the time, analyzed those motions under the standard articulated both in Batson and Davis, and found that the defense had not made a prima facie of discrimination on the basis of race or sexual orientation. But even though it wasn't required to, the OSP, because of the challenges, even though a prima facie case had not been shown, the OSP did provide neutral explanations, both for race and sex, as to each of the preemptive challenges at issue. But rather than grapple with that actual record, which they didn't do, you didn't hear it today, they didn't grapple with the actual record, and they didn't do it in their papers either. Because if you looked at the record and you saw things and the explanations as it relates to the challenges, undisclosed, disorderly conduct incident, a victim of a hate crime, avid watchers of Empire, getting news from TMZ, watching movies that starred Mr. Smollett, Googling the case, getting news only from social media or from Instagram, struggling to understand or hear questions. If they actually grappled with the actual record, it wouldn't fit the narrative that they wanted out in the media. Unequivocally, meritless motions that were offered, the court's prior rulings, all should stand on that point. As it relates to the alleged error number 3, the accomplice instruction on the IPI, the Illinois pattern instructions. As Your Honor knows, the court has discretion to determine which jury instruction should be given. Defense counsel sought, and you heard it here today, to include 3.17, that's the testimony of an accomplice, in the jury instructions. They've done it again here today to try to define the fake attack on Mr. Smollett, which is not a crime, as the crime for which the IPI 3.17, how they would like it to have been analyzed in the application of that instruction. But IPI 3.17 on its face has no application to this case. The Osendaro brothers did not admit, nor was there any evidence, that they were involved in the commission of a crime with the defendant. That's the language from 3.17. What is it? It would be filing the false police reports. And Mr. Smollett, not the Osendaro brothers, made the decision to file multiple police reports, false police reports, claiming he was the victim of an alleged hate crime. The Osendaro brothers could not have been the person responsible for the crime. That's what's required to get a 3.17 instruction, because they did not assist nor participate with Mr. Smollett in the filing of the false police reports. Moreover, Your Honor, the Osendaro brothers did not admit to participating or otherwise being present to the reporting of the fake hate crime to the police. Therefore, they could not have been indicted for disorderly conduct or for filing a false police report. The court properly and correctly exercises discretion in not giving the 3.17 instruction, and that ruling should stand. Lastly, Your Honor, a significant amount of ink was put into the last topic I'm going to discuss, which is the right to a public trial. As everyone in this room knows, this trial took place in the middle of a global pandemic, right on the cusp of the Omicron variant. This court did a great job holding a public trial. All necessary parties, the court, courtroom staff, Cook County sheriffs, the OSP, defense counsel, the jury, media, numerous members of Mr. Smollett's family, numerous of his friends, members of the public at large, were able to attend every single day of the trial proceedings. The logistical efforts for which the defense has taken swipes at this court and this courthouse deserve to be commended, not bashed. The defense objected to having cameras in this courtroom during the actual trial, and they objected to having cameras in this courtroom at every step of the way. And the court respected that objection in declining extended media coverage up until today's hearing. Having the cameras in the courtroom, which they objected to, would have allowed an unlimited number of people to view the trial. Their papers struggle with this. They acknowledge the position. I'll coin it sort of their Goldilocks position. Your Honor, don't make the trial too public. And then once you did that, today it's not public enough. And they've alleged that no members of the press were in the courtroom during any of the jury selection process. Not so. The court knows there were at least two members of the media that were present in the courtroom, probably both of whom are here today, that sat in the corner during the process of voir dire. Many more were sitting at the courtroom exits and standing. These doors were open. Those doors were open. The doors to the Your Honor's courtroom across the hallway were open. Chairs were provided. And while the sheriffs did a great job trying to get people into seats, there were a lot more people that weren't in seats. And for anyone that actually sat in here, which you did, I did, they did, knows there's a lot of people peeking in and out during the voir dire process. The concept that Your Honor closed the courtroom just belies reality. Your Honor kept the courtroom open. Members of the press were here. They were able to keep account of what was occurring. In fact, were accounting as to what was occurring. It doesn't remotely come close to any violation. The Radford case, which we cite, demonstrates that the course use of the entire courtroom for the veneer, but not for the remaining portion, doesn't call into the question the confidence of the public integrity or impartiality of the court system. Mr. Smollett knows he had family present. They sat right there. They had strategy huddles. They passed numerous notes to his lawyers. They held prayer sessions. You allowed his entire defense team, his PR team, his friends. You never took a head count on them. You were gracious in understanding that the defendant's right to a fair trial had to be weighed against a global pandemic. And it was commendable. You did not err, and you certainly did not violate Mr. Smollett's Sixth Amendment right, and he certainly doesn't deserve a new trial. Generally, but certainly for that specifically. With that, Your Honor, if you have any questions, I'd like to turn it over to Mr. Mendenhall.
Mr. Mendenhall?
Your Honor, Ms. Glandian is entitled to her own argument. What she is not entitled to is her own facts. She stood before this court and told you they raised the issue of David Elderby's direct examination. Nowhere in this 83-page motions did they ever make a single complaint about the examination of David Elderby. Ms. Glandian stood before this court and told you that they made a motion to recuse the whole Office of Special Prosecutor, Mr. Webb, myself, Mr. Weaver. Nowhere at trial or in this paper is there such a motion. Your Honor, as we established at trial, facts matter, truth matters, evidence matters. They are not entitled to their own facts. Another fact in this matter, Your Honor, the one disqualification that they did make was to recuse a deputy special prosecutor who examined Mr. Moore. That deputy special prosecutor is an honorable man, is a man I've worked with for 20 years. His integrity is impeccable, his reputation is impeccable, and his ethics is impeccable. Your Honor, they say he put Mr. Moore on the stand to commit perjury. Mr. Moore got on the stand and testified that the person he saw was white. Your Honor is well aware the actual two people that ran by him got on the stand and testified. Abel Osendero, Ola Osendiro. Your Honor, if nothing else has been established in this entire trial, I think we can both agree it's been established that they're not white. Yet they came here today and making that same argument. Their arguments is in wine. They're not getting better with age. Your Honor, to try to discredit a man and to call into question when all he did is serve pro bono faithfully and for free does a disservice to the job that this Office of the Special Prosecutor did. Not only did they not prove anything that merited disqualification, they did it with pure gamesmanship, Your Honor. The rules require that you bring it to the court's attention in advance. They waited till the witness got on the stand and had him point at the deputy special prosecutor. Your Honors, and these are your words exactly, Your Honor, you said this was the first time in your history of a judge where you ever seen a witness get on the stand and point at a prosecutor. I've never seen it. I suspect no one in here has ever seen that. Your Honor, the gamesmanship cannot be rewarded. Their alleged error that the deputy prosecutor should be disqualified, should be summarily denied as meritless. Second point of error, Ms. Glandian raised. She said that the Office of the Special Prosecutor commented on Mr. Smollett's post-arrest silence and post-Miranda silence. We did no such thing. On February 14, 2019, in an unsolicited, voluntary, non-custodial interview with the Chicago Police Department, Mr. Osendero sends Abimbola Osendero a text saying, "Brother, I love you. I know 1,000% you did nothing wrong and never would. Neither you nor your brother. I love you. I stand with you. And I'm going to make a statement making sure everybody knows you did nothing wrong." It was voluntary. It was non-custodial. How do we know it was non-custodial, Your Honor? Mr. Smollett got up and left after the interview. He wasn't taken in custody and was represented by one of the finest lawyers in Chicago. To say that when we questioned Detective Thies about that text, that we put in play Mr. Smollett's post-arrest silence when all of our questions simply asked him about a pre-arrest, pre-Miranda text that he sent when he was free to go and did in fact leave, is wholly without merit, Your Honor. To then say that when Mr. Webb questioned Abimbola Osendero about the same text that he received from Mr. Smollett on February 14th, way before Mr. Smollett was ever arrested, way before he was even Mirandized, is equally without merit, Your Honor. The text stands for itself. Their problem isn't with the question. Their problem is with the text that their client sent, because it said a lot. I know you did nothing wrong. I know you never would. I know 1,000% you did. I love you and I stand with you, and I'm going to make it right. We had every right to ask if that was ever made right. And lastly, Your Honor, they raised an error that we allegedly shifted the burden during trial. They alleged 3 separate times. Once again, Your Honor, facts matter, truth matter, evidence matter. In their 83-page brief, they raised one issue concerning that, and that was at closing. When Mr. Uche stood right there in his very well, looked at the jury and told them, "Ladies and gentlemen, there was a ton of videos missing. There was a ton of evidence missing." The case law is clear on that, Your Honor, that when the defense opens the door in closing argument and raises an issue, the prosecution or the state has an absolute right to respond. They opened the door, and now they're complaining that we walked in it. We walked through it. Your Honor, we simply responded to his claim that there was missing evidence. Detective Thies took that stand and made it abundantly clear. Not a single piece of video was missing. Every video that we had was turned over, and that they had it. No video was missing, Your Honor. And for them to raise that argument, we were entitled to respond, Your Honor. So my role was to address the trial errors. I wanted to do it in a summary fashion because we've been going a while now. But those 3 errors that Ms. Glandian raised are simply not supported by the record. She's entitled to her own argument. She's not entitled to her own facts. We thank you for your time. We respectfully ask that you deny the motion, and the state is ready to proceed to sentencing.
Glenn, anything else you want to add?
Very briefly, Your Honor. Your Honor, Mr. Mendenhall began talking about the second prong of their appointment by Judge Tooman, which was to see if there was any wrongdoing in the dismissal of the charges against Mr. Smollett and the initial indictment. Now, I know there was some public outcry after the sudden dismissal of the charges. However, the OSP did a thorough investigation, and the one thing they did not find was any misconduct on the part of Mr. Smollett, anybody surrounding him or his team, in the dismissal of the charges against him. And that's critical because that impacts the fact that the agreement should have been honored. Now, whatever may or may not have gone on at the state's attorney's office, whatever the inner workings are, has nothing to do with the expectation that Mr. Smollett had when he entered into an agreement. He performed his part. The state's attorney's office at the time performed their part. The court enforced that agreement. And again, we know from the OSP's investigation that there was absolutely no wrongdoing on the part of the defense in bringing about the dismissal of charges against him. That was something that was offered in the discretion of the state's attorney's office, and he was entitled to rely upon it, which he did, to his detriment. As far as the voir dire questions, I just want to emphasize that we're not talking about every single question. I know Your Honor asked a few questions or raised a few examples saying that those are not things that needed to be asked. For the record, I just want to identify the 4 questions that we thought were significant to determine if any of the potential jurors had any prejudices or bias that would deprive Mr. Smollett a fair trial, and the 4 questions that we had asked the court to inquire of the potential jurors and that we believed based on this court's order stating that the court would address these topics were: number 1, are you or is anyone close to you a member of the mainstream media? 2, do you have any particular feelings one way or another about actors? And this was critical because Mr. Smollett as an actor testified. 3, would the sexual orientation of Mr. Smollett or any witness have any bearing on your ability to reach a fair decision in this case? And 4, do you believe that you would give more or less weight to the testimony of a law enforcement officer as opposed to the average citizen? And these were important questions. Again, in light of
Are you sure those questions weren't asked, albeit in my words, not your words? Are you sure about that?
Yes, Your Honor. We've reviewed the record. We put this in our motions. Again,
I think you may be mistaken.
our review of the
but
record
okay.
tells us otherwise. Now, as far as the accomplice instruction, Mr. Weber said that the Osendario brothers could not have been charged with filing a false report because they weren't present when Mr. Smollett reported the attack to police. That is completely absurd. It's like saying somebody can't be charged as an accomplice to murder or a co-conspirator in a murder if they're not physically standing there when someone shoots the gun. It's a silly argument. The Osendario brothers absolutely could have been charged as an accomplice or a co-conspirator. There was probable cause. Despite their denial, they could have been charged. People in courtrooms all across the country are charged every single day with less evidence for conspiracy-based crimes or as an accomplice. They absolutely could have been charged in this case. The CPD and the state's attorney's office made a decision not to charge them because they wanted their testimony against Mr. Smollett, but that doesn't mean they couldn't have been charged, and it doesn't mean that the instruction should not have been given because they do satisfy the requirements necessary requiring that instruction to be given. And Mr. Mendenhall stated, I'm not entitled to my own facts. I'm certainly not here creating any facts. The record speaks for itself. Anthony Moore took the stand. He stated what he stated. We have the transcripts to show that. And he's the one who got up on the stand and said he was threatened and pressured. And when I made reference to disqualification, I certainly wasn't suggesting that we asked for the entire OSP to be disqualified. I was up here. I'm not trying to name any individuals. Our papers are clear as to our disqualification motion. I believe Your Honor already knows that. And finally, just to address the post-arrest silence issue, Mr. Mendenhall wants to isolate the statements as relating to the text message, and he says that these were all statements, or he was referring to the fact that that text message exchange on February 14th was prior to the fact that Mr. Smollett was arrested. However, that's not the question that was asked, and that's not what the jury heard. The questions said, to this day, has Mr. Smollett ever come clean? Has he ever said that the Osendario brothers, it basically says, has he ever corrected the record? And it was specifically, the language was to this day and has he ever. And so that necessarily includes post Miranda, as he was sitting in trial as a criminal defendant. And so we think all of those things were error. And as far as the burden shifting, Mr. Mendenhall says there was no missing video. There in fact was. There was no video footage of one of the taxi rides, which made no sense because it had been, the CPD had apparently obtained that video. However, it was nowhere in the discovery. Later we were told it doesn't exist, but there was missing video, not to mention all of the pieces of surveillance footage that obviously they weren't able to obtain. So again, it was fair game for the defense to comment on those things as the prosecutor's failure to meet their burden and to have the jury wonder about those things. It was not fair game for the prosecutor to do what they did, which is shift the burden and put it on Mr. Smollett to have to prove his innocence and have to come up with this evidence that he simply didn't have. So again, as we ask the court to grant a new trial in light of the totality of errors that have occurred and have deprived Mr. Smollett of a fair trial.
Thank you.
Thank you.
Everybody done?
Nothing further, Your Honor.
Okay. All right. Let me indicate that we've been talking about these very issues for the last couple of years. Most of them are pre-trial, and certainly there's some that took place at trial. I've never had a case that has been pled as exhaustively as this one. Voluminous writings, hundreds and hundreds of pages of filings asking for multiple motions to dismiss, jeopardy claims, motions to disqualify counsels, all of which are contained in the post-trial motion. It's fair to contain them in the post-trial motion, but I mention now that these have been vetted and records have been made, and I've articulated myself at great length on all these issues in the past. And I am comfortable with the colloquies that were had and the decisions I made as a result of those colloquies. Just a few matters right now I want to address, and I think I should because they've been brought up with some passion by Ms. Glandian. There has been some suggestion that somehow this court should not have allowed the second indictment to go forward because it was invalid, because somehow Judge Leroy Martin, Chief of the Criminal Division at that time, when he appointed Michael Tuman, or asked Michael Tuman to be the one to preside over Sheila O'Brien's petition seeking a special prosecutor, that somehow that was flawed, that Judge Tuman, when he held hearings, and he held exhaustive hearings, and his report speaks for itself, that somehow those proceedings were flawed and a special prosecutor never should have been appointed, and that I somehow should have been in a position to grant some kind of collateral relief and dismiss the second indictment because the appointment of special prosecutor in the first place was invalid. I've read all of those transcripts, everything that took place in all of the hearings before Judge Martin and then Judge Tuman. Judge Tuman issued his report. He took it under advisement, and believe me, there were lengthy hearings that were held on this matter. He found that the appointment of a special prosecutor was necessary. Now, that doesn't mean that he's assuming that Mr. Smollett's guilty of something. It didn't mean that he assumed that the Cook County State's Attorney's Office was guilty of some misconduct or had done something terribly untoward or unethical. All it meant was that under the totality of the circumstances, a second look was necessary, that public confidence in this entire affair was shaken and a second look was necessary. He appointed Winston Strawn, Dan Webb in particular. I find nothing wrong with Judge Tuman's reasoning, his analysis. I'm not sure I have the right to offer a collateral remedy because I'm just a trial court judge on the same level as Judges Martin and Tuman. But be that as it may, I happen to agree with their reasoning that they found that the appointment of the special prosecutor was necessary, and all they did was investigate, and then they found things after that. A report was made about the Cook County State's Attorney's Office, and obviously a second indictment came as a result of their investigation about the circumstances of the case involving and the conduct involving Mr. Smollett. All right, that's that. As to a public trial, we were in COVID. This was the first jury trial that this court had, and I am an active jury litigator and have been for years and years and years. This is the first trial I was able to have since COVID, and COVID was still happening. We were under all kinds of constraints. I was told that I could only have half capacity in the courtroom, including the jurors, including the deputies, including the lawyers. I had multiple lawyers on each side. I think the defense team is 6 lawyers. The prosecution with their staff has even more. I asked the parties, how many seats do you need in the courtroom? The defense came to me at first and they said, we need 42 seats in the courtroom. That's 42 out of 57, including the jurors. I had media requests. The defense told me specifically, I asked them, do you want cameras in the courtroom? Shall this be televised? The defense said, no, we would not like it televised. The prosecution said, we don't take any position. Whatever Your Honor decides is fine. But I deferred to the defense. I understood that this is a delicate matter and preferred not to have it on television. So I agreed. There shall be no television. I did the best I could to have a public trial. We did things that we don't normally do. We kept the doors open. We had seats outside the doors that were open. We had seats set aside for the media because I knew that the media would be making this as public as possible. We did have people coming to the courtroom, and ultimately, and there was no limit on the amount of people that were here as family and supporters of Mr. Smollett. So I am confident that I did all I could to give a public trial that the Constitution requires. We were under severe limitations based on the COVID virus. Last thing I want to talk about is the accomplice instruction. There's been a lot of talk about this, and I did take this seriously at the time when it was brought up. We have to remember why we are here. Mr. Smollett was indicted for filing a false police report, felony disorderly conduct. Everything about what happened between he and the brothers, the plan that the jury found happened, the scheme to meet on the street and pretend to beat him up and call him names and do the things that they did, none of that's a crime. There was, because Mr. Smollett was consenting to it, not only consenting to it, he had orchestrated it, according to the evidence. There's nothing you could find the brothers guilty of. They didn't commit any crime. The only crime that was at play in this entire scenario was the false police report. When the police were called, the brothers were no longer there. They weren't consulted. They were out of the picture. The problem that Mr. Smollett has are what he said to the police and what the jury found that he said to the police, and that it was patently false. That was the problem. And the brothers had nothing to do with that. And because the crime at issue was the filing of the false police report, the felony disorderly conduct counts, I found that the brothers had nothing to do with that portion of it, and the accomplice instruction for those reasons would not lie. And so I just want to put that to rest. And we talked about that at length previously, and I know Ms. Landian is serious about it, and that's fine, but I see no problem with that. As to the rest of it, we've talked about this for 2 years, and I have made records both orally and in writing on each of these issues, even some things that were not raised orally today. I'm going to stand by my findings and rulings. I do believe at the end of the day that Mr. Smollett received a fair trial, that he was proven guilty beyond a reasonable doubt by the jury based on the evidence that was presented, that there was nothing unconstitutional about these proceedings. His motion for post-trial relief is respectfully denied. We're going to go further. I'm suggesting we take a short recess, and then we're going on to a sentencing hearing. Let's take 10 minutes. you let your colleagues know that we're ready to start, please?
Sure.
You find them or text them or something?
Sure.
Thank you. You be seated. We're just waiting for your colleagues. All right, everybody ready to resume? Thank you. Okay. We're at a sentencing stage now. Pre-sentence investigation was ordered and has been received. Does either side have any corrections they wish to make to the pre-sentence investigation?
Your Honor, on behalf of the state, no.
Sorry.
Any corrections or amendments?
No correction, Judge.
All right. Then we'll proceed on further. I will inquire of the government, do you wish to present evidence in aggravation, either witnesses or documentary evidence?
The answer is yes, Your Honor.
Sure. You may do so.
Mr. Mendenhall will be
Okay.
presenting the witness statement.
Your Honor, I have a victim impact statement that I would like to, I've been asked to present on behalf of the City of Chicago and Superintendent Brown of the Chicago Police Department. As you correctly pointed out, is of some length, so I tried to condense, and I'm only going to read the relevant portion, but I will point out for the media and for the public watching, the full statement has been filed and made available to the court, as well as defense counsel. So again, Your Honor, the letter is on behalf of Stephen Kane, Deputy Corporation Counsel, and David O. Brown, Superintendent, Chicago Police Department. As the jury concluded, Mr. Smollett falsely reported to the Chicago Police Department that he was a victim of a hate crime. Specifically, Mr. Smollett told the CPD that two people attacked him, placed a rope around his neck, poured a chemical on him, and called him homophobic and racist slurs, and stated that this is, quote, MAGA country, end quote. Mr. Smollett claimed he did not know his attackers, but that one of them was white-skinned. A massive investigation ensued, costing the city and its residents well over $100,000. For the following weeks, more than 30 Chicago police officers and detectives investigated Mr. Smollett's report by conducting witness interviews, reviewing over 1,500 hours of surveillance video, in-car camera videos from taxis collected by detectives, as well as other evidence. These same detectives also gathered documentary evidence, including rideshare records, store receipts, store videos, and knocked on doors, going door to door during the polar vortex, one of the coldest periods in Chicago history. During this period, the detectives and police officers worked around the clock, amassing over 1,000 hours of overtime in an effort to solve what in the beginning was thought to be a horrible hate crime. The overwhelming stress and fatigue that was put on the Chicago officers who were involved in the case was immense. While the city can address the financial costs of Mr. Smollett's false report and the investigation that ensued, a cost that can never be measured is the harm caused by reducing the likelihood of actual victims of hate crimes willing to report these crimes. In CPD's experience, hate crime victims are frequently hesitant to come forward and cooperate in police investigations out of fear that they will not be believed or they will be targeted for additional crimes. Members of these communities often feel marginalized even before suffering the indignity of the hate crime. When crimes are not reported, the perpetrator is not punished and remains free to commit other crimes, endangering public safety. This is particularly problematic in the context of hate crime because these crimes harm not only the individual victim, but also others who share the victim's trait, creating fear in the broader community. Falsely reporting hate crime have a tremendous chilling effect on the real victims. Indeed, Mr. Smollett himself acknowledged that, quote, "You do a disservice when you lie about things like this," end quote. The financial cost of investigating Mr. Smollett's false hate crime report was significant. CPD spent 1,426 hours in regular shift time investigating his false reports at a cost of $67,500 $734 in employee time. CPD also spent 1,837 overtime hours investigating Mr. Smollett's false report, costing the city $130,106. A spreadsheet calculating these expenditures is attached as Exhibit A. Your Honor, we respectfully submit that restitution for the city is warranted here. Illinois law authorizes restitution to compensate the victim of a crime for out-of-pocket expenses, damages, losses, or injuries found to have been proximately caused by the conduct of the defendant. Government victims may recover restitution for expenses that go beyond the normal cost of investigating crime. That is exactly what happened here. The city is a victim of Mr. Smollett's crime because of his false report caused CPD to expend scarce resources that could have been devoted to solving actual crimes, increasing public safety. The city is not seeking restitution for the regular salaries of the officers involved, but CPD's overtime expenses that go beyond the normal cost of investigating crimes and are thus recoverable. A restitution award as part of Mr. Smollett's criminal sentence would enable the city to avoid these costs and delays. For these reasons, we respectfully request that you seek restitution for the city in the amount of $130,106 as part of Mr. Smollett's sentence. Sincerely, Stephen J. Kane, Deputy Corporation Counsel, City of Chicago. David O. Brown, Superintendent, Chicago Police Department. Your Honor, a copy of the full letter has been made a part of the record. Thank you.
I've received it. Thank you. Does that conclude your evidence in aggravation?
Yes, Your Honor.
Okay. Does the defense have evidence, witnesses, or documents that they wish to present in mitigation?
Yes, Your Honor.
Sure. You may proceed, Mr. Allen.
Thank you.
Judge, we would call witness Rich Daniels.
Rich Daniels, sir, please step up right here. Hi. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, self you got?
I do.
All right. Please have a seat. Try to keep your voice up. You're welcome to take your mask off if you want to. If you
Thank
prefer
you.
to keep it on, that's okay too. It's entirely up to you.
Thank you.
Ms. Waddell, you may inquire.
Thank you very much, Judge. Sir, in a loud, clear voice, would you please introduce yourself, state your first and last name, and spell your last name?
Sure, my name is Richard Daniels. My last name is Daniels. And I'm sorry, what else did you ask?
Sorry. Mr. Daniels, how old are you?
Oh, really?
Yes, sir.
I'm 61 years old.
All right. And are you familiar with a person by the name of Jussie Smollett?
Yes, I am.
How are you familiar with him?
I met Jussie 8 years ago this month when I was the music director on the television show Empire, for which I was the on-camera music person for all 102 episodes and all 6 seasons.
So in what capacity did you know Mr. Smollett while working on Empire?
Jussie was the breakout music star on the show, and as the music director for the on-camera work, I worked with him closely, daily, for many years of the show, as helping to support him in terms of his role on the show.
All right. Now, in terms of his role in the show musically, how did you help support him in that way?
We put musicians on camera around him in the 6 seasons that we did Empire. We would put around Jussie and other cast members and guest artists, musicians from the community. So 400 different musicians and vocalists appeared on that show from the local Chicago community over the 6 seasons we had the show, many of which performed with Jussie, and many of which he embraced dearly as friends over that period of time.
Did Mr. Smollett also have any hand in making sure, securing any of these musical artists for the
He
show?
would sometimes voice opinions and give me approval or tell me what he's looking for, so of course there was interaction that way. And through that process, we became very good friends.
So outside of the show, you said you became very good friends. What type of things would you say you did with Mr. Smollett?
I was very active, and I continue to be active in the world of nonprofits in Chicago, supporting various things. And so I would tell Jussie about certain things that we were active with, And as a celebrity, I would say it would be very meaningful if you might consider participating and donating your time and your talent, which he willingly did on many occasions. And it was always a very meaningful experience for those who saw him and interacted with him, and meaningful for those of us who brought him out.
Now, Mr. Daniels, I'm going to ask you briefly to, if you can, go through just a few of these nonprofits or any of them. I know that there's one that was relevant with the Boys and Girls Clubs of America.
That was a meeting we had that never went beyond the meeting stages. But the one that was really relevant was a school on the west side of Chicago. Grade school, and it has 505 African-American children. I believe it's the largest population of African-American children in a grade school system in America. That's what they talk about. Magnificent school. I was brought in a few years prior to Jussie coming in, asking to support it in various ways, and their mission was so great it was easy to jump in. I asked Jussie if he'd come over. He willingly said yes, and it was an extraordinary life experience because we didn't tell the children who was coming that day. And it also led me to believe of what a huge show Empire had become in the African-American community. We didn't tell the children he was coming to their classrooms that day. Each classroom we walked into with Jussie, the children jumped up with joy, ran to him, hugged him, cried with him. It was an amazing experience. It was cathartic to witness it and to see it happen because the impact he had as his celebrity and as this loving, wonderful young man was dramatic. It was really quite something. I was very taken by it, as were those who were with me that day, as were the people who were administrators at the facility. And that was one example of the many that he participated in, of giving his time and his talent. He is a very charismatic young man. He's a very loving and caring young man. And, he was generous, and he was thoughtful, and he was kind, funny, and intelligent, and I just think the world of him.
Now, aside from his time, talents, energies, charisma, all of these beautiful things that you just stated about Mr. Smollett that he willingly and abundantly gives, would you say that he anything else of himself or from himself to communities or anybody else around him?
I know of charitable contributions he's made in large sums of money, and I know of large projects he supported financially in addition to his time and talent. So he covered all the bases of time, treasure, and talent in terms of his giving and his willing to participate in the community. And it was always with a loving heart. It was always with a willingness to do good and to give back to what he had been given. He knew he was a lucky young man. This show Empire, this was catching lightning in a bottle for all of us who were able to be on it. There were 593 scripted television shows made in America last year. 593. I think back to when I was a kid and there were like 12. And there were 593. So content is everything. So the competition is fierce. Empire was one of 3% of all television shows to get beyond 5 seasons. Doesn't happen. We think of shows that have long lives to them. That's fine. But the number of shows that have long lives, very few and far between. So Jussie had an appreciation for that, what he was given, as did all of us on that show. It was a game changer for Chicago. The community embraced that show in huge ways. The first episode of season 2 had 29 million viewers. Those are major sporting event numbers, and that made Jussie a huge presence in the community, both in television and in the community at large.
Would you say that based on all of Mr. Smollett's contributions that he was absolutely a pivotal part in the show's success?
Oh, he was. He was the music star of the show. I'm sure that Terrence and Taraji and anybody else would tell you the same thing. Jussie was the music star of the show. Everyone else participated in it, but he was the day in, day out go-to music guy. He was our breakout music star on the show.
Now, Mr. Daniels, would you be willing and able to support Mr. Smollett if he were given a chance at a term of probation in this matter?
Of course. It's part of my daily activity and the thing I'm most proud of.
Believe that there would be issues that Mr. Smollett would ever exhibit on a period of probation?
None that I would have ever seen or ever thought of.
We have 1 moment, Judge. Thank you.
Is it okay to take a sip?
Yes, sir.
Just going back briefly, Mr. Daniels, of all of the incredible services you said Mr. Smollett gave himself to willingly, those were not required of Mr. Smollett in any way, were they?
They were not.
Neither by the show or any agency that you're aware of?
No, absolutely not.
So you believe that in addition to any of the, again, services that Mr. Smollett gives willingly of himself, that if he were given a term of either probation or some kind of community service, would you be willing or able to either supervise that or make sure that he would be compliant and continue to give himself to community service and service of others?
Absolutely. Happy to.
Thank you, Mr. Daniels.
Thank you.
Any cross-examination?
No, Your Honor.
Mr. Daniels, thank you.
Thank you, Your Honor.
May I call your next witness?
Yes, Ms. Gilman.
Please step up. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, Your Honor.
Thank you. Please be seated. Try to keep your voice up. You're welcome to take your mask off if you like. If you want to keep it on, it's entirely up to you. Both masks.
Good.
Mr. Allen, you may depart.
Thank you. Ma'am, please state your name
Sharon Gelman,
and spell your first and last name for me.
SharonGelman.
I know my mother would kill me for this question, but I'm not going to have to ask how old are you?
62.
Okay. And what do you do for work?
Well, now I'm a writer, editor, and a nonprofit consultant, but for many years I ran a nonprofit called Artists for a New South Africa.
Okay. Without telling me your address or anything, what state do you live in?
I now reside in Maryland in the Washington, D.C. area.
And did you fly in for this specific purpose?
I did.
And why specifically did you fly in for this purpose?
Jussie's like family to me. I've known him for well over half of his life and a good chunk of my own. And I came because I was hoping that I could help people see the Jussie that I know.
So do you remember around the time you first met Jussie?
I met him in 1999.
That's very specific, okay. And so why does that stick out, 1999 when you met him?
We were producing an event. It was the 10th anniversary of my organization's existence, and it was the 5th anniversary of South Africa's new democracy. And we were doing a specific portion of the event. Desmond Tutu was our keynote speaker, and ambassadors, and Sidney Poitier. We were doing a specific portion which was about the role of young people in the struggle against apartheid. And I asked the artists who were founders and our board members who would be like a wonderful young artist, someone with great talent and great heart to include, and they all suggested Jussie Smollett, and it was in that context that I met Jussie, who at that time was doing, was her representing her, working on her behalf.
So back in '99, Jussie would have been a younger man.
He was 16.
Right. Even back then, what were your impressions of Jussie?
Well, he was when I called and spoke to him. We wrote a letter asking Journey to participate, and I got a very professional phone call back from someone named Jussie, and I was very impressed with him. And he said, I do public relations for Journey. And then he came into the office to meet me, and in walked this like utterly beautiful young man. And I was like, oh my God, you're a baby. But that was when I learned he was Journey's brother.
Did you even get the feeling back then in '99 that Jussie understood the significance of the event that he was attending in South Africa?
Oh, yeah. Well, first of all, the whole Smollett family is very charitably and politically engaged. And, Jussie and Journey were very excited to be involved. I mean, I think Jussie, because being raised up and exposed to the arts and entertainment community from a very, very young age as little children, they understood the power that that fame confers, and they also understood the responsibility. So they loved the idea of using Journey's very baby, embryonic star power to do something good in the world.
Sure. So after '99, did you continue to have a relationship with Jussie?
Yes, Journey and Jussie and Jake and Jazz and Janet, the whole J family, would often come in and volunteer. They would stuff envelopes. I mean, they were like a all-service vehicle that, it's like, do you need us on stage? Do you need us sweeping the floor? They would just do all kinds of things. And then, gosh, I think it was around 2006. It might have been late 2005. We needed another staff person. We were a tiny organization, and I hired Jussie then, and he came and worked for me full-time for 4 years in the office.
What was Jussie's role after he was hired?
Well, he started off as my administrative assistant, and he will forgive me, I hope, by saying that Jussie has many talents. Paperwork is not really one of them. But he was so good with the staff and with our volunteers and with our interns. I mean, we were a tiny organization, and we did big things, and we depended on the largesse, not only of our celebrity members, but also of students and grassroots community folks who came in. And Jussie just was really stellar at making everyone involved, from the highest and mightiest and most world-renowned to, the kids we were working with in the inner city, making them feel special and welcome. And we worked really hard, and he was one of those people who had the rare gift of making hard work fun. So he really played a very, very pivotal role, and I promoted him pretty quickly. He became the coordinator and manager of our charity auctions, and then we produced an audiobook in honor of we announced it on Mr. Mandela's 90th birthday, and we released it on its 91st birthday with a major publisher and 26 celebrities from all over the world, renowned people of all backgrounds. And Jussie, was very involved in coordinating that. And as I said, he was willing to do anything. He was willing to, go pick people up. He was a good photographer, so he would document the sessions. Anything that needed doing, Jussie was willing to do it.
Great. I got a little starstruck when I heard Nelson Mandela and Desmond Tutu. So what exactly did your organization do?
Well, we were founded in 1989. Alfre Woodard and brought together a bunch of people. It was during the height. We didn't realize then that it was towards the end of apartheid, but it was the height of still continued conflict, and she had been with the Congressional Black Caucus, and they were talking about people needed to go back and work in their communities. So Alfre came back and organized her community, and I got involved. I think I showed up at the third meeting. I heard about it, and I never left. We raised money. We raised awareness. We over our years, we raised and granted $9 million to frontline groups in South Africa doing African-based, African-led organizations doing AIDS work, democratic development, youth education, economic development, and we harnessed the ability of our members to raise awareness about HIV/AIDS prevention and treatment, about the voting process, both in South Africa and in the U.S. We always tried to match what we were doing in South Africa with a related issue locally, either in Los Angeles or in the United States, so that we weren't, being those people who care a whole lot about something thousands of miles away but don't care about the community that you can drive to or live in.
So during Jussie's time working there, I heard that you put him in charge of charitable contributions, which
charitable auctions.
Which seems like a very important job. Can you describe that?
He did. I mean, that was one of the things he did. Yeah. But for that, what he would do is he would contact our donors and celebrity members and others of resources and ask for things that we could either auction off live or online, so live at a big event or online. And so it would be everything from, I think our two highest money-making things, or our three, were Gillian Anderson, who was a board member, gave us passes to the wrap party for the final season of X-Files. Jackson Brown let us auction off, I think it was, he let us auction off someone coming and working with him in a studio to record their song, which ended up being a really long process because the person wasn't a musician, but we earned a lot of charity dollars in the process. And then I think our other highest generating item was a private luncheon with Archbishop Desmond Tutu.
So this is from 1999 when you first met Jussie. Now we're at from 1999 to 2010, since he worked those 4 years. Can you explain the growth in his character you observed during that time?
Well, Jussie, I mean, obviously he went from being a very young, adolescent to an adult. I mean, I would say his character was the same. He was a very open-hearted, hardworking, pure-hearted person. I mean, he didn't have a car. He rode a bus 1 hour each way to our office, and sometimes I would drive him partway home, and he would always be like, no, I'm fine, I don't mind. It's like he was like, I'm so excited to get up every morning and do something to make the world a better place. I mean, he was like evangelical in that way of really believing in the cause, and he got paid very little. We wanted all of our money to go to the front lines, but nonetheless, he got paid really little. And every time I would sort of apologize to him for that, he would be like, no, like I'm so, like, I feel so excited and lucky to be part of this. And we became friends. I mean, I loved all my employees and I believed in them, but Jussie and I also became real friends.
Wow. So after 2010, did you kept in contact with Jussie?
Oh, absolutely, regularly.
In what way, mostly?
Well, sometimes it would be him wanting to figure out a way to make a difference. So he had witnessed all these people, Sam Jackson, Denzel Washington, Sidney Poitier, who could use their position to benefit others. And so that was such a deep part of who Jussie was, and he also understood it from helping those people to do that work. So sometimes he would call. I remember him calling me right when the story broke about the water in Flint, Michigan, and he was literally sobbing on the phone, just going like, I can't believe what's going on, and I really want to make a difference, and here's what I'm sort of thinking of, and would you help me figure out if it's the right way to go? And I want to give money, but I also want to go and bring supplies, but I also just want to show up for people, and I want to, he was always trying to figure out how to do what he could do best. And a lot of what he did in those ways, I mean, he understood the power of standing up for people, and that the TV cameras would follow, and that maybe others would follow his example. But he also did a lot of what he did during that time anonymously and quietly, but he still did the due diligence of figuring out which group is good and how do you figure that out, and I'm going to call people I know and do my research so that my dollars are well spent and are making a real difference.
Sure. So Jussie went from taking a bus to your office to becoming a worldwide phenomenon on a TV show. Did you notice any change in his personality when he gained that phenomenal success?
Not really. I mean, he was still Jussie. He was funny and sweet, and he was so, like, effervescent about this magical thing that had happened to him. And I think for all of us who worked with him at ANSA, Artists for New South Africa, whether board members or, we were all so thrilled for him. It was like, we all knew he was talented. We had him perform at a couple of our events once he started performing musically, and we were all fans. And but we were. He wore it well. He wore his fame responsibly, and he understood. He understood sort of the requirements that come with that kind of position if you want to be a good, decent person living in the world.
So if Jussie was given a period of probation in this case, would you be willing to help supervise to make sure that that probation period goes fantastic?
Absolutely. I call on Jussie. I've called on Jussie to help me on things all in these years after he's worked for me. Most recently, in the middle of all of this, I was helping with an auction for Desmond 90th, which ended up being his final birthday before he died. And I called Jussie and asked for his help. And I was like, I'm sorry to do this while you're going through all this. And he's like, no, God, this is like, thank you. This gives me something else to think about. And he really went out of his way, bent over backwards to try and get some contributions. So I would be honored and would take it very seriously if to help Jussie continue to be a really deeply contributing member to society.
Okay. One moment, please, John.
Sure.
No further questions, Your Honor.
Thank you. Any cross-examination?
No cross-examination, Your Honor.
Ms. Gelman, thank you kindly.
Thank you.
Other witnesses you care to call?
Yes, Judge. Judge, we'll be calling Joe Smollett, Mr. Smollett's older brother. He's going to give a statement to the court. And then
Okay.
afterwards, Mrs. Smollett's grandmother will
Sure.
also give a statement.
You come up on the witness stand, please.
Can you go right in there?
If he prefers.
Yeah.
He's just going to read a statement, a narrative?
Yeah.
All right, I'm not going to put him under oath. I don't think it's required, but please, Mr. Smollett.
Good afternoon, Your Honor. Your Honor, before I just wanted to say a few things. I don't know if it was done sarcastically, but mentioned my family earlier, Mr. Weaver, about us passing notes and prayer sessions. Trying to understand that my brother right here is on trial. And while this might just be a level 4 felony to a lot of people, under the circumstances, this has felt like the reincarnation of Al Capone's trial, okay? To be honest. And it's not your fault. I'm not trying to say it's your fault, I'm not saying. But the way that this has been, so that's probably the reason you see us sharing notes and doing prayer sessions. My mom's 69 years old. She was born in 1952 in Texas. All right? She knows a thing about racism. She doesn't really need a lecture about the extent of racism. Neither does an openly gay African-American man. All right? I strongly believe, you know what I'm going to say, I strongly believe in my brother's innocence. But I'm not going to rehash try to relitigate the issues in the case today. Your Honor, I come before you humbly to request leniency when you sentence my brother. Please remember that we are currently living in a time in which we are enduring a vicious pandemic, extreme economic uncertainty, a major conflict in Eastern Europe, and global paradigm shifts taking place everywhere. As human beings, we are collectively worn down. But Jussie Smollett is not at the source of the socio-economic and political problems on Earth. On quite the contrary, he is a man who has been a beacon of hope, charity, and philanthropy to his nation and to his community. He has made real efforts in his lifetime to promote equality and love among all of humanity. He has expressed strong political views and has stood against injustice wherever he thinks it may lie. His criticism of powerful individuals, organizations, and practices does not make him a bad person, okay, or someone who should be punished. It simply makes him an American. I'm sure that Mr. Dan Webb was once on former President Ronald Reagan's radar for his criticism during the Iran-Contra prosecutions, all right? But standing up to powers and authorities in America is part of what makes us American. And he turned out to have a pretty successful career after he stood up to power. Jussie does not have malice or hatred toward anyone, and it is truly unfortunate that his reputation has received so many negative connotations, and he has never received the benefit of the doubt or a proper presumption of innocence. And even though I completely disagree with the jury's decision in this case, I am not attempting to rehash it here. I only want to give support to the point that Jussie should not be incarcerated. Jussie Smollett is my younger brother. I know you're going to think I'm biased. I am 5 years older than he is, and I can remember him at infancy. He has always been a loyal, loving, and creative human being. He is not a threat to the people of Illinois. And in my humble opinion, Jussie is completely innocent, but even for those, once again, who think he is guilty, the crime he has been accused of is not even considered a felony in most states. Furthermore, here in Illinois and in Cook County, disorderly conduct is oftentimes not even prosecuted and charges are frequently dropped. Incarceration of any kind would send the wrong message, especially in a time in which we as a nation have expressed in a bipartisan plurality the desire to see real criminal justice reform and an end to unnecessary mass incarceration, which predominantly affects African Americans, Hispanics and Latinos, and poor and impoverished white people. We also know now that as a nation that calls itself free, we cannot do so while continuing to incarcerate more nonviolent offenders than any other nation in the world. Mass incarceration is also an unnecessary burden to the taxpayers, to law enforcement, and it is simply unjust and wrong. For those who believe that Jussie is guilty once again and needs more punishment, I would also ask you to consider the gut-wrenching and stomach-turning punishment he has already experienced for the last 3 years. The TV show that he poured so much labor and commitment into making a success was ripped away from him even before he was criminally tried. The fact is, the overwhelming majority of mass and online media reporting in early 2019 resulted in a premature assumption of guilt, and the court of public opinion had already convicted Jussie in early 2019. For the last 3 years, he has had to live in anxiety and in a certain kind of pseudo form of house arrest. As a public figure, he has had to deal with public scorn and the real security threats associated with being an accused celebrity. He was, in essence, quarantining almost a year before the COVID-19 pandemic even began. Now, we all know the Sixth Amendment of the U.S. Constitution guarantees the right to a speedy trial. In my opinion, it is unfathomable for me to stand here in March of 2022 pleading with Your Honor not to give my brother jail time for a low-level offense that is alleged to have been committed in early 2019. For those who believe he is guilty, once again, trust me when I say that the punishment he has already received has far exceeded the actual alleged offense that you accuse him of. Your Honor, there's been a lot talked about, restoring public trust. In my opinion, you don't restore public trust by demonstrating to the public that a level 4 felony, which once again is not even what he's accused of, not even a felony charge in most states in America, by giving him a stiff sentence, which includes jail time. That's not restoring public trust. That's in my opinion, all right? And if you were to go 5 miles in any direction in this area, from this courthouse, and talk to people in the community, you're not going to say, they're not going to tell you, oh yeah, we restored the public trust because Jussie Smollett went to jail. Trust me, it's not going to happen, all right? This is not restoring public trust, all right? We are dealing with a lot of things in the world right now, and sending him to jail would not be restoring public trust. So please also keep in mind that, like myself, many people view this case as nothing more than a he said, she said kind of case, all right, with no evidence to have warranted his conviction in the first place. With that in mind, Your Honor, I am humbly requesting that your sentencing of my brother not include any incarceration. I myself and my entire family will be eternally grateful. And I thank you for your time.
Thank you, sir.
Thank you.
Is there an additional witness that would like to say something today?
Yes.
Mr. Allen, how about a chair? Would that be helpful?
I'm gonna.
I need a mic.
She's the boss, Judge. She's got to tell me where to go.
I want to be heard.
Okay. Fair enough.
Thank you so much. Sure. Thank you, Your Honor. Okay. Good to be here. Okay.
All right.
I thank you for this opportunity to allow me to make this statement. My name is Molly Smollett, and I am 92 years old. I have lived in New Mexico for over 25 years, but I am originally from New York, where I was a film editor. I am the proud grandmother of Jussie and his siblings. I felt compelled to come and tell you that the Jussie I know and love does not match up with the media's betrayal of him. And I'm talking to you guys. You haven't done a good job on investigative reporting. I've worked on documentaries. I know what it is. I've gone through the McCarthy period. I marched with Martin Luther King and the March on Washington, and I'm here now. And so you got to do better. I challenge you to do more investigative reporting. Jussie himself, as you've heard from the testimonials, is a very gentle, kind, and generous young man, and his empathy is infinite, which translates in giving of himself. Jussie has always been active in the pressing issues facing our communities, such as HIV/AIDS, voting rights, and other urgent social problems in America. One Christmas, he went to Flint, Michigan to entertain children who were living with lead poisoning from their drinking water. What the media may not know is that Jussie is what I call a justice warrior. He has been active against injustice all his life, as his mother has, who is an incredible rock for her children. And as my son, their father, who sadly passed away from cancer 7 years ago, only in his 50s. And I know in my heart that my son, Jussie's father, would have wanted me to come here to tell you who the real Jussie is. I also have fought against injustice forever, and I feel it's in our DNA. I attribute this to being Jewish and the persecution of my ancestors. The Hebrew words tikkun olam means to repair the world, and that's what I do, and that's what Jussie does. I will end by saying that Jussie is loved and respected by all who know him. And I ask you, the judge, not to send him to prison. If you do, send me along with him, okay? And I thank you for letting me talk. Thank you so much. And thank you all. It's nice to be in Chicago.
Thank you kindly.
Thank you.
Shay, you can help her get back
Thanks.
with the family.
Yeah, thank you so much. They have suffered so much.
I see.
Okay. Thank you. Okay. Okay. The next one. Thank you.
Right. Mr. Uche, any other live witnesses you care to present today?
Judge, none at this time. I believe, I'm just checking Mr. Allen real quick. Okay. No, Judge, just the statements to be.
Okay. All right. I've heard evidence in aggravation, evidence in mitigation. I'll now entertain arguments in aggravation and mitigation, starting with the Office of Special Prosecutor.
I'm sorry, Your Honor.
I'm sorry. Excuse me.
You want us to
Yes. Okay. Okay. I know what you're talking about. I have received numerous letters on behalf of Mr. Smollett. Some of them as recent as today, this morning. And I think it's only fair to publish and spread of record who those letters are from. Generally, they're all asking for mercy. They all know him in different capacities. They're strongly advocating for him. But you can tell me who those letters are from. And I think the special prosecutor has also received the same letters that I've received.
Yes, Your Honor.
And if you want to paraphrase a little bit from the letters, Mr. Allen, you're welcome to.
Sure. Your Honor, the first letter here is from the organization Black Lives Matter. Dear Judge Lynn, Black Lives Matter stands in strong support of an alternative to incarceration sentence for Jussie Smollett. We applaud your long-held practice of imposing alternative to incarceration sentences for virtually all Class 4 felonies, such as Mr. Smollett's, and encourage you to continue this practice in this case. We know that second chance probation, regular probation, and deferred prosecution are all options. As we contemplate what creates a truly safe world, we know that Mr. Smollett's case involves no drugs, no theft, no sex, no property damage, and no physical injury to anyone other than the defendant. Despite the attention paid to it by the media, at its heart, this case involves a low-level, non-violent offense. We urge the court to keep this truth in mind when sentencing Mr. Smollett. We know that the cost that will be expended to met out a sentence involving jail time will be much better used providing much-needed community service. We first came to know Mr. Smollett long before Black Lives Matter's growth into the largest racial and social justice movement in global history. Mr. Smollett has an extensive history in civil rights advocacy and philanthropy. Mr. Smollett personally donated more than $500,000 to Black organizations and gave $125,000 in proceeds from his music tour to organizations working for Black, LGBTQ+, and women's rights, including Black AIDS Institute, which provides high-quality, direct HIV services to Black people, Flint Kids Fund, which funds programs aimed to address and mitigate the impact of lead poisoning and trauma suffered by many children in Flint, Michigan, the Trayvon Martin Foundation, whose main purpose is to provide emotional and financial support to families who have lost a child to gun violence, and Know Your Rights Camp, whose mission is to advance the liberation and well-being of Black and brown communities through education, self-empowerment, mass mobilization, and the creation of new systems to elevate the next generation of change leaders. In 2018, after learning that Bennett College, an all-women's HBCU, was on the brink of losing its accreditation, Mr. Smollett and his brother helped the institution raise the funds needed to retain accreditation. In fact, although the college needed only $5 million, Mr. Smollett and his brother led a campaign that raised $8 million. Beyond his financial contributions, Mr. Smollett has been a fixture in civil rights organizing. We have marched alongside Jussie in fights for health care, to draw attention and resources to the AIDS epidemic, for women's rights, to protect the sanctity of families, and in peace walks. Our relationship with Jussie goes back to the early years of Black Lives Matter, or at least 2016. And it has continued. Despite his struggles with this case, most recently we sat with Mr. Smollett during the anniversary of Trayvon Martin in February 2022, where he flew to Miami to serve as a loving face in the crowd of support families whose loved ones were stolen by police and or vigilante violence. In short, Mr. Smollett has demonstrated a long-standing commitment to helping others. Incarcerating Mr. Smollett would be solely punitive in nature. Mr. Smollett does not pose a threat to anyone. Thus, we respectfully request that this court impose a sentence that is an alternative to incarceration, and that's sincerely Melina Abdullah, PhD, the director of Black Lives Matter Grassroots. Also have a letter here from Latanya and Samuel L. Jackson. It's very short, so. I write to you today to ask for mercy as you sentence Jussie Smollett. I understand the difficult nature of your job as you seek to make decisions which take into account the crime and the punishment. It is in respect of knowing this that I humbly implore you to please find an alternative to incarceration for Jussie Smollett. It is my understanding that Jussie was convicted for Class 4 disorderly conduct, which, to my understanding, people convicted of this offense historically are sentenced to various alternatives to incarceration.